Hello, and thank you so much for joining me today, learning a little bit about estate planning basics. Today, we're going to be touching on some of the important documents that are needed for your estate plan, who you should be speaking with, what should you be looking forward to, what steps do you need to take to create or start your estate plan. We'll be digging on this presentation, but first, do want to let you know that you do have access to see what webinars that you would like to listen in on at various days and times throughout each week. We do many of these presentations, and every week there is something going on, so please look out for those. You can listen in on our Invest Savvy podcast, and you can also check out our ARIS website and blog. So as we start to talk about estate plan, what is an estate plan? It's a map. It reflects the way you want your personal and financial matters to be handled in case of incapacity and or death. So this is not just if someone passes away. What if you were in the hospital? What if you were in a coma? Who's going to help pay your bills for you? Who's going to do the financial things that might need to be done, whether you are still here but incapacitated or if you pass away? Who's going to be doing these, and how do you want to direct someone for that according to your wishes? If things are not put in place, then certainly things could potentially be done, but maybe not according to the way you would like them to be done. So who needs an estate plan? Not just for the wealthy. Without an estate plan, you can't control what happens to your property if you die or, again, become incapacitated. Makes your wishes clear, avoiding family disputes. I've worked on many different, unfortunately, estate issues where someone passes away, and many times family and money do not combine very well. Proper estate planning can preserve assets and provide for loved ones. An estate plan is especially needed if your spouse is not comfortable with handling financial matters, if you do have or are in charge of custodian of minor children. You would definitely need to have something in place. If your net worth exceeds the federal transfer tax exclusion amount, here it says $13,610,000. It's going to be highlighted a few times throughout this presentation of this dollar amount. Just know that in 2025, that is actually a little bit closer to 14 million right now, which is this number has increased over the years. And if you own property in more than one state, or if you have financial privacy concerns, and if you are a business owner, these are many different reasons why you would want to have an estate plan. Basic estate planning concepts: planning for incapacity, healthcare, property. So these are some of the important documents that we're going to talk about for healthcare. Who's going to be able to make healthcare decisions for you? Who's going to have access to accounts if you are incapacitated? Planning for death, wills and probate, tax basics, lifetime gifting, life insurance, and finally trusts. All of these pieces are part of an estate plan. Planning for incapacity. If you were in a hospital, or if you were, what if it was a dementia issue, if you had Alzheimer's or something like that, that you were not able to act financially or make your own healthcare decisions. If you needed someone to do this, you need to put this in place before these things happen. So incapacity can strike anyone at any time. Failing to plan means a court would have to appoint a guardian. Lack of planning increases the burden on your guardian, and your guardian's decisions might not be what you want. Planning for incapacity is a very important issue, and age really may not matter on that. There's no discrimination on age when it comes to incapacity. A famous case, which if you are old enough to remember, a case of a person named Terri Schiavo. Terri Schiavo in 1990 was a 26-year-old who went into cardiac arrest. She had massive brain injury because of that. She was in a vegetative state for about 8 years. After that 8 years, her husband wanted to remove the feeding tube and let her go naturally after that. Per Florida law, this happened in the state of Florida, but her parents, Terri Schiavo's parents, opposed this. So it came down to they ended up putting the feeding tube back in this case, and then it was the fighting in court of who had the right to make the decision, the spouse or the parents. So now we're 11 years later where the court sided with the husband to remove the feeding tube, only to have it again reinstated. And this is in Pinellas County in Florida. George Bush at the time, president at the time, got involved in this. Federal courts were getting involved, and this was nationwide news of what is going to happen with this. Fast forward 15 years after the initial date, so this happened in 1990. March 31st, 2005, she did pass away. They sided with the husband to remove the feeding tube and let her go naturally. So it was a 15-year process, and this is because there was no written directives on what someone wanted to have happen. So again, we're talking a 26-year-old person, and ouch, it's certainly something that can be avoided if you have documentation in place. Healthcare directives is a big part of that. If you have a living will, durable power of attorney for healthcare, and a DNR, do not resuscitate order. So a living will puts your instructions in writing that if you do pass away, what do you want to have happen? And then durable power of attorney for healthcare, if you are still living but incapacitated, lets you designate someone to act on your behalf, who's going to put your best interest at stake there. Do not resuscitate orders. My mother-in-law, as an example, had this in place, and she had cancer at the time. She did go into cardiac arrest, and they were taking some measures. And then when it came time to try to do more for her, intubating her and doing more, the family, the daughters of my mother-in-law, all got together and said, we have this, she's got to do not resuscitate, do not go to extra measures, and they did let her go naturally then. But you can put that in place if that is your wishes. Planning for incapacity for property management or accounts. How do people help you? Adding joint owners on accounts could certainly be helpful, whether it's savings accounts, checking accounts, brokerage accounts. You cannot put joint people on IRAs or retirement accounts, but you can have a power of attorney if someone needs to help that is not joint on an account that still can act on your financial matters or property matters. And also you can create a trust. We'll touch on this a little bit later as well, but creating a trust and putting accounts in this trust where you are what is called the trustee of your trust. But if you are not able to act, then it would be determined that the successor trustee, the next in line, who you would select this person or people to become the trustees. So the successor trustee moves up to the trustee, and they can act on your behalf then, whether you are living or not living. The successor trustee can still act according to your predetermined wishes. What happens if you die without an estate plan? Some property passes automatically. Maybe if you have joint ownership on accounts, those would pass without any issues. Same thing if you name beneficiaries on retirement accounts and IRAs, life insurance, or if you have a trust. Other property generally passes through according to state intestacy laws, basically probate. So what happens if you die without an estate plan? Intestacy laws vary by state. Typical pattern of distribution divides property between surviving spouse and children. Your actual wishes are irrelevant. This goes by state law now. Many potential problems could certainly come up. Here's an example of something like that. If a husband, father, passed away, maybe the husband wanted his accounts to go directly to his spouse. Pay bills or just, living in general. But in this case, the state law may be determined that the spouse gets 50% and the children get the other 50% split, in this case, a quarter each. So maybe that's not the wishes, but this could have been a state law provision. Assets would have been divided that way. Wills and probate. A will is a cornerstone of the estate plan. It's the most common thing that someone might do, that you want your wishes to be in writing. Directs how your property will be distributed, names an executor and guardian for any minor children. You would have that if you were in charge, if you have minor children or caring or a custodian of a minor or disabled person maybe, who is going to care for these people. You can name that in the will. can accomplish other estate planning goals. And also you wouldn't want to make sure if you do have an estate with assets, with a sizable assets, that you would want to start to think about tax situations. It's written, signed by you, and witnessed. The probate process, most wills must be probated, which a will opens up probate. A will is filed with the court if someone passes away. Executor collects assets, pays debts, files tax returns, distributes property to heirs. Typically, process lasts several months to a year. I have been personally involved in this when my parents passed away. My father passed away in 2015. My mother was diagnosed with cancer about 4 weeks after my father passed away, and she passed away a year later. So in 2015, my father passed away. 2016, my mother passed away. And we found out that she didn't get to everything. She did update her will after my father passed away. She took some measures. She took my dad's name off of the property, off the condo that they owned. But there was a couple of accounts that did not have beneficiaries named, no joint people. And one of the accounts actually still had my father's name still on it. So she didn't get to everything. And when she had passed away, we had the updated will. So we go see the attorney after my mother passed away. And this again is in the state of Florida. And so he's looking at, I'm one of 5 children. He's looking at all 5 of us saying, here's the will. But the first thing I do is I go and file this with the court. And it becomes public record. Filing with the court opens up probate. In Florida, it's about a 6-month waiting period. And we couldn't touch some of the accounts, especially those 2 accounts that did not have beneficiaries named. Anything that did have a beneficiary, her IRA, a couple other smaller accounts, things like that, we were able to close out and put in our own individual names. That was all fine, but there was a condo worth estimated value at the time is about $220,000, and then 2 accounts totaling about $80,000. So we had a $300,000 estate that went through probate. It was a 6-month waiting period. After that waiting period, thankfully, no one came forward. If someone does come forward and says, hey, this person was going to leave me some of these assets, now that is contested. That could drag on, add more fees, and it could be a very lengthy, expensive process if that does happen. But if you have beneficiaries named, if you have maybe the home in trust, or you have joint people on the home, that can avoid all this probate. And so when we had spoken with the attorney, got all this set, after probate ends and we're finalizing the estate, we ended up putting the condo on the market and did sell that condo. And then we got the bill from the attorney for roughly about $9,000 for to handle this probate. Where if we took care of everything up front, boy, that could have saved everyone a lot of time and money. So the pros and cons of wills and probate. Time and costs are typically modest, except for the cons here. You'll see the fees, the attorney fees that came into play. Court supervision, protection against creditors. Thankfully, my mother, the home was paid off. She didn't have credit card debt, no bills, nothing like that. So we didn't have to protect anything, but just in case if there is debt, then that can certainly be taken care of, or the court will protect you on that. The cons can be a time-consuming process and title transfer delays. We had to wait to put the condo in our name. And then finally, not finally, but fees. So we had, again, a $9,000 bill from the attorney for this. And ancillary probate, again, it becomes public record. Anyone can see this estate if they choose. So can you avoid probate? Absolutely, yes. An estate plan can make sure that all your wishes are documented. You have the proper documentation, the proper ownership of accounts, maybe joint owners, or making sure you have beneficiaries named on everything, and even your property. Maybe that's in a trust, but own property jointly with rights of survivorship, complete a beneficiary designation for all your accounts, especially retirement accounts and life insurance. Use trusts if needed. And this is something that if you're not sure if you need a trust, yes, we can certainly have a conversation with you and start to get this figured out with you. But ultimately, you might need to speak with an attorney to create some of these important documents. Make lifetime gifts. You can start to gift money to other people legally without taxes. So tax basics, transfer taxes include federal gift tax imposed on transfers you make during your life. Federal estate tax, this is if you have a sizable estate over that close to $14 million or close to actually $28 million if you are married filing joint. And federal generation skipping transfer tax, where you gift to people more than one generation below you, so grandchildren or great-grandchildren. And transfer taxes imposed on the state level tend to affect smaller estates. So you could check with your state to see if you have state potential taxes when someone passes away. So the federal gift tax, there's a lifetime transfer amount that you, the donor, gift to someone else, and you can gift to anyone. It doesn't just have to be a family member, but the gift tax applies to transfer made during your lifetime. Certain gifts are excluded. You can gift any person each year. It's the 2025 number is now 19,000. We'll see this 18,000 number a couple of times, but just know that this year it's 19,000 that you can gift any person each year. Up to 13,610,000. Again, that number this year is a little closer to 14 million in 2025. So that's the lifetime amount that you can gift someone, and for your estate to avoid estate taxes to have it under that 13 million. Now, most people that I work with are well under this number, but if you happen to be someone that does have an estate over this number, especially if you're married filing joint over close to 28 million, then you would absolutely, definitely, if you don't have something in place now, you have to get something in place very soon for that. And the 13 million or closer to 14 million now exclusion is the largest in federal gift and estate tax. Here's an example of an estate tax issue that happened not too long ago, but if you remember an actor, James Gandolfini, he was famous for his Sopranos. He died suddenly, heart attack, at around age 50-ish, and he had a sizable estate estimated to be about $70 million estate he had. There was no estate plan done, no documentation, no trust. The bottom line is 70 million going through estate. There's outside of this exclusion. So let's say that happened this year and 14 million of that is not subject to the estate tax, but everything over 14 million up to that 70 million is subject to a 40% federal estate tax, plus potentially any state taxes on there. So if you have wealth like that, you definitely need to put something in place. The tax basics of the federal estate tax, a transfer at death, your estate pays your beneficiaries. The estate tax applies to transfers made at death, generally does not apply to transfers made to a spouse or a charity. So if you have a close to $14 million estate or even higher and you pass away, that can go to your spouse without estate taxes to your spouse. But once the spouse passes away and that goes to someone else, whether that's children or whoever else might be beneficiaries, could be subject to the estate tax then. So that close to 14 million now excluded from all transfers is combined in 2024, closer to 14 million in 2025. Any portion of exclusion used for gifts will be unavailable to the estate. Further here, a new feature important for married couples, it's portable. Here's where I said that if one spouse passes away, let's say the husband passed away with an estate of even, let's say, around that 14 million, that goes to the spouse without estate taxes. Once that second spouse can pass away, then it could be subject. So it's called portable, where it goes from one spouse to another without estate taxes. So in this case, right now in 2025, it's a little closer to that 28 million can be left to beneficiaries tax-free. But if you have an estate above that 28 million, then there could be estate taxes. The federal gift tax, the generation skipping transfer tax, is your estate. When you're skipping children, you're going directly to grandchildren. That could be, again, there's that same close to 14 million exemption. But again, if you have a sizable estate and you are skipping generation, there could be taxes involved in that. Unlike the gift tax, this is not portable. So if a spouse passes away and that estate goes to the surviving spouse, then it goes downhill. It does not double to that close to 28 million. So here's the last 2022, 23, and 24, where you could see that exclusion was just over 12 million, then close to 13 million, 13.6. Now it's a little closer to 14 million for these exclusions. But you can see the top rate, 40%, is what that estate tax is. Lifetime gifting lets you see the recipient enjoying your gifts. So if you want to start gifting while you are still alive, lets you minimize. Again, this is up to 19,000 that you can gift. If you have, let's say, 2 children, you can gift one child 19,000. You can gift the second child 19,000. If you are married filing joint, your spouse can gift one child 19,000. Your spouse can then gift the second child 19,000. So each child can have 38,000. So now you're talking 76,000 that can be gifted without taxes each year. And you can gift, again, grandchildren, you can gift friends, neighbors, relatives, whoever you want, you can gift up to this 19,000 without it being taxed. Removes future appreciation of property from your taxable estate, and there's no step up in basis. Your basis in the property carries over instead. Lifetime gifting, you can give 18,000 or now 19,000 to as many individuals as you want. Estate tax, federal tax free, so 36 or now 38,000 if you have a spouse and you want to gift together. If you're contributing to a 529 college savings plan, you can give 90,000, 180,000 in this case if you have a spouse, gift tax free, but those payments have to be made directly to the 529 plan. Not gifted to someone to put in the 529 plan. You would have to, even if someone else owns that 529, you can gift directly to that 529 college savings plan and avoid taxes on that. No gift tax on amounts paid directly to a school for individuals' tuition. So if you want to pay someone's tuition, you cannot gift the child or the student the tuition money to pay tuition. You have to pay that school directly. And same thing with medical care. If you want to pay someone's medical bills, those have to be made by you directly to the medical care provider. If you need to create a trust, that's certainly something that many people do now. You don't have to have extreme wealth. Maybe you just have a home that you want to title in the trust to make sure that home avoids probate if you passed away. It's a versatile estate planning tool, can protect against incapacity, avoids probate. That's the biggest thing. You want to avoid probate, and allow professional management of assets, provide safeguards for minor children. There's a couple of examples that I have over time of people that have had a trust. One example was a couple that I worked with who had a trust, and they had a special needs person living in this home with them. And they had it in their trust. The house was titled in the trust, but they had directions in there that if they were both deceased, if they both passed away, that home could not be sold as long as the special needs person was alive. They said this person will always have a home. Whoever the successor trustees are, they have to manage it, but they cannot sell that home. It would be for that person to live in. So can protect assets from future creditors, control over property. Trust. So what is a trust? It's a legal entity that holds the property. So it's a separate entity than yourself, but you control it. If you would be what's called the grantor or the trustee, and maybe many times you're both in these, but if you have a trust, you control it still, even though those assets are outside of your personal estate. The trust is a separate entity. Parties to a trust are the grantor, the trustee, and the beneficiaries who you would name. in the trust. There's the most common is a living trust, or potentially a testamentary trust could be created. We have that in place if we were to pass away and if we had assets, and our children were still minors. Minors cannot hold assets. So basically a testamentary trust would be created for the minor children until they're the legal age, 18 or 21, depending on the state. And revocable trusts and irrevocable trusts. Most people that I work with do have what's called a revocable trust, a family trust, a living trust. There's many different terms for that, but generally a revocable trust. People with wealth that need to get assets outside of them for estate tax purposes, it would be an irrevocable trust. If you're looking at that over close to $14 million, or if you are married filing joint of over $28 million, then irrevocable trust would come into play. Life insurance can provide instant estate. So even if you don't have assets or very minimal assets, but you have life insurance, let's say $100,000 death benefit, or $200,000, $250,000, $300,000, $500,000 or more, that would be part of the estate. Life insurance proceeds can provide needed estate liquidity, so you can get those once a death certificate is available. Then life insurance proceeds pay out fairly quickly. Life insurance proceeds are included in the estate for the federal estate tax purposes. So if you have sizable assets, maybe under that 28 million married filing joint, but you pass away with a very sizable life insurance policy that puts you over 28 million, that again is part of the estate tax, that total. Key issue is ownership of policy. So here's that irrevocable or the irrevocable trust, where if you have irrevocable life insurance, I'll kind of breeze over this a little bit. I'll still explain it, but this is again for most people that are the people that have extreme wealth and are looking to get assets outside of their estate. So if you are the insured person in this irrevocable life insurance trust, the irrevocable trust owns the policy. You cannot be the trustee of your own irrevocable trust. Someone else, this is the part that how it's outside of your estate, is someone else is the trustee for this. You would still be the insured. It's based on your life. So the irrevocable trust, and then the insurance company, and then you would name beneficiaries in this. You create an irrevocable trust and you name a separate trustee, and you name the beneficiaries. The trustee then purchases the life insurance on there, and again, payments would upon your death would go to your beneficiaries. You can make cash gifts to pay the premiums for this, so you would make a regular gifts to it. Beneficiaries technically can withdraw cash gifts during a limited window of time, and the trustee uses those gifts that you provided or put into this irrevocable trust, and the trustee uses the gifts to pay the premiums on that life insurance. And so at death, the insurance company pays the irrevocable trust, who pays the beneficiaries. The irrevocable trust gets those proceeds. Because it was outside of your estate, proceeds are not subject to the estate tax, that 40%. And they're distributed according to the terms of the trust to the beneficiaries you would name. So in conclusion, have you implemented a plan for your incapacity, health, or property? Do you have a valid will? Are transfer taxes a planning concern for you? Does your overall estate plan reflect your current wishes and circumstances? Thank you so much for your time today and learning a little bit about the basics of estate planning. I would love to have that one-on-one conversation with you, or even with someone else if you would prefer on my team, and we can get that conversation going to see if you do need to speak with an attorney to create your trusts or wills or powers of attorney, whatever those important documents are needed. Again, thank you so much for your time. Have a wonderful day.